All right, let's go ahead and start. Let's put phones away. Raise your hand if you turned in the paper in both formats. Raise your hand if you have turned it in one format but not the other. All right, so as always, the easiest time to remember to do this is right now, because if you forget to do it like now, then none of us are going to remember until we're handing the papers back in 2 weeks, and then you're going to say, where's my paper? And I'm going to say, did you give it to me in both formats? So try to do it now. As long as it came in on time in one format, it's on time, but to get a grade, you got to give it to us in both formats. Yeah, you can go ahead and bring them up if you got it. So as always, we'll get through them as quickly as we can. It's a large stack, and these ones are longer, obviously, than the previous stack. So it'll take us a little while, but we'll get them back to you as soon as we can. And I guess that's all I'll say about that. The Supreme Court's in the news a little bit this week. Did anybody catch any of that? What did you see? There's a couple different items. Yeah.
They blocked President Trump's DACA ban.
Yeah, I mean they didn't. That's not quite precisely stated correctly, but so one of the things that was in the news is that Barack Obama, when he was president, issued an executive order providing like exemption from deportation for dreamers, right? Certain categories of immigrants who came to the country illegally as children. And President Trump last fall repealed that executive order with a 6-month window. He repealed it in September with the repeal to take effect in March. And some immigrant rights advocates, including some state governments, challenged that repeal and in court, and 2 lower courts blocked the repeal temporarily. They haven't issued a final decision yet, but they said in the meantime we don't think the repeal should go forward. And the Trump administration had urged the Supreme Court to reverse those decisions and allow the repeal to take effect, and the Supreme Court refused to hear that case, right? So this is something the Supreme Court often does. They don't give any public explanation. They just refuse to hear the case. In this instance, the explanation is clear, which is that the Trump administration was asking the court to hear the case earlier than normal, right? The lower federal courts, it had not gone through the various steps in the lower federal courts that it is supposed to go through, and you are entitled to ask the Supreme Court to step in earlier, but they very rarely do it. And so they said they're not going to hear that case, and the practical immediate effect is that at the moment, the Trump administration is not allowed to repeal DACA. So the Dreamers remain protected from deportation at the moment. What else did you see in the news from the court this week? Only that one? Anything else? A couple other things that were in the news. Yep.
I can't mention the exact case, but it was the one about the labor union.
Yep. So, and did you hear anything in particular about it?
Just very vaguely that labor unions are taking in dues and supporting candidates, but not all the people that are paying dues agree with.
Yep. So this is an issue. It's one of the more high-profile cases on the court's docket this term. They haven't decided it. They just heard oral arguments in it yesterday. So that's why it was in the news this week. When the court hears arguments in the case, the media is there and they report on it. And so the decision will come down sometime in June. The way that labor unions work, typically, state laws are slightly different from state to state, but the way they work typically is if the workers in a particular workplace vote to join a union, then that union is the legal representative of the workers in that workplace. And there's a lot of complicated legal disputes about, which workers count and which workers are eligible to be members and the like. But basically, there's a federal government agency that says, there was a vote, and the voters in that workplace voted, and so the labor union is now the representative for this group of workers. And the union is required to represent the interests of all of the workers in that unit, legally required, right? So even if somebody chooses not to join the union is still required to represent their interests. So if the union negotiates for higher wages, that guy who's not a member gets the higher wages too, right? And because that creates a free rider problem of folks could say, oh, well, I'm not going to join the union, I'm not going to pay the dues, but I'll still get the higher wages that they negotiate, right? States have passed laws to try to address this, and one thing that many of those laws state is that once there's been a vote, once the workers vote to join the union, a majority, then everybody's required to kick in a little bit, right, their fair share payment to support the activities of the union. But if the union is also engaged in other kinds of activities, like endorsing political candidates, people shouldn't be forced to contribute to that because they might not support those candidates, right? So in many unionized workplaces, you have like 2 tiers of payments. If you're a member, you pay dues every month and they get deducted out of your paycheck. If you're not a member, you don't have to pay dues, but you still have to pay a smaller payment to cover the costs of the union's representation to all the workers. In this particular case, a worker who does not want to join a union and does not support the union's activities claims that he should not be required to pay even those costs, right? He's not paying to support any of the union's political endorsements. He's paying to support the union's bargaining and representation activity in that workplace, but he doesn't want to even pay that. And he argues that it's unconstitutional, violates the First Amendment to make him pay that. And there was an identical case that came to the Supreme Court last year, and the Supreme Court was set to decide it, and the expectations were that it was going to be a 5-4 decision against the unions, and Justice Scalia passed away before the case came down. And the court was then divided 4-4, and their procedure in such cases is they don't decide it. They issue a brief order that says this case is dismissed by virtue of an equally divided court. We just can't decide it. So whoever had won in the lower court had won for that particular case, but there's no precedent decision from the Supreme Court. President Obama nominated Merrick Garland. Republican Senate refused to consider his nomination. President Trump won the election. President Trump nominated Neil Gorsuch. And identical case came back to the Supreme Court. And so we know for sure in this case that Neil Gorsuch has the deciding vote, because on an identical case last year, the other justices were divided 4-4. So that's something to watch. So the closest parallel to understand what the impact of this case on unions will be is that a few years ago in Wisconsin, Scott Walker, the governor of Wisconsin, pushed through a law that made this change just in Wisconsin law, right? No public sector worker can be forced to pay any fee that they don't want to pay to a union. And public sector unionization rates dropped dramatically in Wisconsin after that, as folks are no longer required to pay the money, so they decided not to pay the money, and so this is an effort to impose that same rule nationwide, and so it would have a big effect on unions, and that's why people are paying a lot of attention to it. At least one other item from the Supreme Court I caught in the news this week of interest. Anybody else catch anything else? Colin?
There was some discussion about the Second Amendment.
Okay, so there's that too. I forgot about that one. Yeah, did you catch what that was?
Yeah, they were criticizing the cavalier attitude towards the Second Amendment and how, there's not been...
Who was criticizing it?
The name is escaping me right now.
So Justice Thomas, so there was a Second Amendment case. So the court gets about 8,000 petitions every year, and it hears about 80 cases a year, which is 1%. So the vast majority of petitions to the Supreme Court, what happens is the Supreme Court just says, we're not going to hear this, we don't have time for that one, it's not important enough, whatever, hasn't got our attention, we don't give any explanation. About a decade ago, the court issued 2 famous, well-known Second Amendment decisions, which we will talk about this semester, and since then it has not agreed to hear any further Second Amendment cases. It just keeps ducking the issue. And there's been lots more cases brought, like lots more gun control laws have been challenged in court under the Second Amendment, and the court keeps refusing to hear them. So the court refused to hear this case, and Justice Thomas, Clarence Thomas, wrote a dissenting opinion, right? There's not even a decision, right? The court did not decide the case. The court just decided not to hear the case. But it's a dissent from the court's decision not to hear the case, right? So it's Justice Thomas writing opinion saying we should hear this case. And he went off a little bit about how there's been multiple Second Amendment cases that have been coming our way and we keep ignoring them for some reason. I don't think there's any justification for that. I think we should hear this one. I think the lower court decision is probably wrong. I think we should review it closely. And I think we should pay more attention to the Second Amendment. So that was in the news. There was another case in the news, which a couple of you wrote about. Who wrote about Class versus United States? There was a couple of you who wrote about that one for paper number 1. This is a case where, as a criminal case, somebody pled guilty, right? Pled guilty, and then subsequently tried to appeal and say that the law under which he was convicted was unconstitutional. And in fact, that's partly a Second Amendment case too, because he got convicted for a gun crime. And the lower court said, no, you can't appeal the law as unconstitutional. You pled guilty. Like when you plead guilty, you're like saying, we're done. Like, I'm guilty, I'm agreeing, we reached a deal, right? They offered probably to lower the sentence, and if I plead guilty, they'll sentence me to this. And you signed that deal, and then you can't try to undo that by claiming that the law was unconstitutional. And he appealed to the Supreme Court, and yesterday he won. And the Supreme Court said, nope, if you plead guilty, there's some things you're not allowed to subsequently try to raise after that. But if the law under which you were convicted was itself unconstitutional, that's something we would want a court to take a look at, even if you did plead guilty. And so you could still go forward. The court didn't say that the law was unconstitutional in this case. It just said it can go forward. He can make that argument in court, even though he pled guilty. And one noteworthy thing about that decision in Class versus United States yesterday was that it was a 6-3 vote, and the 6 justices in the majority were Ginsburg, Breyer, Sotomayor, and Kagan, who are the 4 Democratic appointees on the court, plus Chief Justice Roberts, plus Justice Gorsuch. And so Roberts has done this a couple, right? The court does not always polarize on political lines. It does it pretty regularly, but it doesn't always do it. Roberts has sometimes voted with the more liberal justices, even though all his conservative colleagues are not doing so. That's happened in a couple cases, and we'll talk about some of them. This is the first instance in which Gorsuch did it, right? Yes, he's only been on the court, for a year, less than a year, and so he hasn't had that many cases yet. But this is the first time he's done it, and so that's noteworthy. And people are like wondering why he did it, and if it's a signal of is he going to do it more often or not. So that's something to keep an eye on. So one of the things, as we have shifted our attention from the Warren Court era of the 1960s towards subsequent constitutional developments, you're going to see that more and more regularly we are discussing in class constitutional conflicts that are directly relevant today, right? And so I'm going to encourage folks to keep an eye on what's happening at the actual Supreme Court for the remainder of the semester, however your news feed works. Let's see if you can adjust it to get the Supreme Court showing up in there, because I'll be asking some questions about that. Okay. So our topic today is civil rights. And so in many ways, from here on out through the rest of the semester, I don't think this is true for every single day, but it's true for a lot of them, we are going to look at a topic that we have already looked at, right? So civil rights is something that we have already talked about, but we are going to look at developments that have happened on this topic since the Warren Court, including sometimes current developments, right? Things that are happening right now. So go back to the 1960s for a second in your mind. You all are lawyers, government lawyers. You work for the state of Virginia. It's 1965, say. You are government lawyers in the state of Virginia, 1965, and the policymakers come to you, whoever, like the Speaker of the State House or whatever, comes to you and says, Brown versus Board of Education, right? We've been trying to ignore it for a decade. It seems like that's not working so much anymore. We keep losing these cases. I'm feeling like we got to start changing some of our policies here in the state because of Brown versus Board of Education. Can you tell us exactly what's allowed and what's not allowed? Right? Not just on schools, right? But on racial equality more generally. What are we allowed to do? And what are we not allowed to do? Take a second and see if you can write something down. This, by the way, is most of what lawyers do. If you want to be a lawyer, most of it is not courtroom litigation. It is advising people on what they are legally allowed to do or not, right? Occasionally, if it winds up in the courtroom, like something went wrong, right? You're supposed to keep people out of the courtroom. So, right, just jot that. I'm going to ask you verbally, but just collect your thoughts for a minute, jot something down. Can you come up with a clear sentence or two guiding the state of Virginia regarding what they are and are not allowed to do under Brown versus Board of Education? Again, not just about schools. Not just schools, but how does that apply more broadly to any kind of activity that the government of Virginia might be involved in? What does Brown tell them they can't do anymore? All right. What do you got for me? I'm the Speaker of the Virginia House. Tristan, what do you got?
The government is not allowed to limit access to public facilities. So if there are things that are being operated by the government, you can't segregate things.
Okay, give me another word for things. Like what?
You can't segregate the clientele of these public facilities.
Okay, if there are public facilities being operated by the government, which would include schools, but include some other things too, right? The people who are using those facilities cannot be segregated on the basis of race. What else, Quentin?
So if segregation happens in a place where segregation is basically stopping the personal development of the African American children, because you quoted a lot of sociological papers
Yeah.
in the local decision, then you cannot do it. So segregation is not possible in this situation.
Good. So Quentin's comment sort of builds on Tristan's a little bit, right? So one thing is, okay, we're probably not supposed to be racially segregating public facilities that are run by the state, particularly if that racial segregation somehow negatively harms the African Americans, in particular African American children, who are supposed to be using that facility. So again, schools is an obvious example there. What's another potential example besides schools? Do you have something else in mind? Yeah?
I thought about museums.
Museums, right? So if the state's running a museum. What?
Any public place, like government-run public places, like public pools, maybe.
Yeah. Public swimming pools was a big one at the time, right? They were always segregated. White people did not want to swim with black people. It was a huge conflict over and over and over again, right? So if this is the logic of Brown, right, then that seems like that's not allowed anymore. Just like it's not allowed with schools, it would not be allowed with the swimming pools either. What else you got down? What other advice you got? Yeah?
Must protect equal rights as they pertain to schools and other public places or government institutions so as not to advantage or disadvantage persons of differing races.
Okay, good. So this is similar, but a slightly different way to phrase it, right? Tristan and Quentin both emphasized segregation in public facilities. And our third lawyer now is saying protect equal rights so as not to disadvantage, is that what it said?
Yeah.
Members of any particular race. Is that?
Or advantage.
Or advantage, not to advantage or disadvantage members of any particular race. Did you have any particular kind of thing in mind?
Well, I mean, we're going to get into it.
Yeah,
so-
sure, we are. Okay, so just slightly different formulation. We'll come back to that. What else? Anybody else have something down that's not quite directly the same as what we've already said? Yeah.
Well, the state of Virginia cannot deprive the citizens of their equal rights and protection on ground of race by account or in effect. So, like, if it's one of those things that are not like directly related, but when it came into effect, it's like advantage or disadvantage like specific race. So that's not okay either.
Okay, so this is a little different than what we've said so far. So Jimmy says the state is not allowed. Tell me if I get your words right. The state is not allowed to disadvantage, is that what you said? Any particular race, either directly or indirectly. Have I right?
And if the court is making the judgment, I guess that would be right. If somebody else is trying to make that argument.
Well, at the moment, I'm a policymaker and you're my legal advisors, right? And so I'm trying to say, well, suppose that I do want to comply with the Constitution and federal law. What do I have to do, right? And so you're giving me the advice. So I'm trying to do the right thing here, grudgingly at least, right? I'm trying to comply with Brown versus Board of Education.
Right.
And so you're telling me what we got a bunch of policies and we're going to have to change some of them. And you're telling me which ones we're going to have to change. Did you have some particular kind of thing in mind that we might have to change?
Well, if there's one law that complies with one of those things the court repealed and said that this thing might come into effect and disadvantage some person based on race, then maybe we should change that.
Okay, right. So that's still not quite a specific example, but it's a kind of example which we're going to look at. There are some laws that explicitly discriminate on the basis of race. African Americans are not allowed to go to this school. That explicitly discriminates on the basis of race. There are some laws that in the text of the law itself does not say anything about race, but that have the effect of harming disproportionately members of a particular racial group. Those might be unconstitutional after Brown, depending how we interpret it. Right? All right. I'm not done with my lawyers yet. I got some follow-up questions. All right. So this is a little bit helpful, the general advice, but I got some specific things we got to decide. I got 4 specific policies I need your advice on. So give me an answer on each of these on your paper first, and then we'll talk about them. Number 1, state of Virginia has a law that says blacks and whites may not marry each other. Are we allowed to keep enforcing that law or not? Number 2, the State Department of Corrections, right, prison department, has a policy that for every newly admitted inmate, right, when they first are delivered to the prison, every new inmate is initially housed in a 2-person cell in a special intake wing of the prison for the first 2 months till we get to know them a little better. And those two-person cellmates are always assigned the same race, right? If you are white, your cellmate is always white. If you are black, your cellmate is always black. That is our long-standing policy. Not permanent, but for the first 2 months, because we have had problems of racially motivated violence in the prison, and we want to figure out whether you're a member of a white supremacist gang or some other kind of gang that is going to engage in racially motivated violence before we house you in the general population. Can we keep doing that? Yes or no? That's number 2. Number 3. Our state police force has a set of application procedures, a bunch of complicated different stuff that you got to do if you want to join the state police force. And part of those procedures include taking a civil service exam that tests vocabulary, reading comprehension, and the like. Someone did a study that showed that this exam, that different racial groups have on average been performing differently on this exam. So requiring this as a condition of application has had the effect of disproportionately excluding members of some racial groups from the state police force. Can we keep using that exam or not? That's number 3. Number 4. The University of Virginia, flagship state university, public institution run by the state of Virginia, has an admissions policy which gives a boost to members of any racial group that is currently underrepresented at the university. So if Latinos make up 20% of Virginia's population but only 10% of UVA students, then we're giving them a boost, unless and until they reach parity, at which point we'll get rid of it. Can we keep doing that? That's number 4. Kyle?
What year are we supposed to be a lawyer in?
You're supposed to be a lawyer. Well, what I said was 1965. UVA did not have any such policy in 1965. So, but I did say 1965.
So mindset of 1965?
Well, yes.
Looking at the Constitution of 1965?
Right. I mean, the text of the federal Constitution from 1965, which is basically the same as the text now. I don't know. Mindset, that's trickier. I wanted it in 1965 because interracial marriage was still illegal in Virginia until 1967. And so you can't, the time periods don't match up exactly for all 4 of these examples. But so stick with 1965 in your minds for the moment. All right. You got answers down for everything? Need anything repeated? Okay. Raise your hand if the marriage law is unconstitutional, in your view. Number 1. Okay. Raise your hand if the prison policy, number 2, is unconstitutional. Couple tentative hands. Okay. Let me start with you 2. Why is the prison policy unconstitutional?
Well, I mean, it's clearly discrimination based on race. I mean, I know it's temporary and I know it's for a specific cause, but I mean, when we were going over what you can and can't do, we didn't mention anything to do with prisons or anything to do with safety. And I just feel like once you start going down that road, it just, I mean, obviously, just like anything else, we start taking away like certain things. It can just be a slippery slope. So if we start saying like, oh, you can't do it because of safety in prison, then you can say, oh, it's, who knows, it's not safe to marry someone of a different race because that could create hostility between families or something. So I just feel like we just use that for everything. So I feel like it kind of just can't go there at all.
Gotcha. You wanna add anything?
I mean, pretty much said what I was going to say. It's a pretty hairy situation, but fundamentally it's still a form of segregation. And I don't know, also I'm sort of thinking when you go to jail, you do sort of waive some of your rights.
Sure.
So if you do end up in a situation where you're a black person with a white supremacist roommate, it's a little bit trickier, but it's like, I have no idea where that stuff is going. I'm gonna take that back. But also,
you do waive some of your rights. You don't waive your rights to
So
be
you don't
like
have
murdered by
But
yourself.
also, like if they're white supremacists, you should be able to figure it out fairly quickly, just with some max.
Right.
So like, you don't have to like have them in the same cell for the first 2 months. If there's a problem, like fix it.
Okay, so this last point is important. There might be a more minimalist way. The government has some important interests here. They don't want inmates murdering each other. That's important, right? But there might be a less intrusive way for them to meet that interest without racially segregating inmates for 2 months, potentially. Yeah, fine.
So, in this case, does security but equal rule applies?
The cells are all of equal quality, let's say. I don't know if that's actually true in Virginia in 1965, but this example is not actually from Virginia in 1965, although it is from a real case. Okay, most of you said the prison policy is okay, so why? Yeah.
Just straight off compelling state interest in protecting the prisoners.
Seems like a pretty important government interest.
Yeah, it's compelling interest, and it's narrowly defined enough so it doesn't apply to other things.
Right. They didn't say maybe it's not as narrow as it could be, but it's not permanent racially segregated prisons, right? It's temporary. So whatever, they got some file that comes to us, but we don't know what's in there. We don't know if anybody's been paying attention to them, right? So they engaged in armed robbery and they got convicted, but we got to actually observe him and see how he's interacting with other inmates before we can figure out for certain whether he is in some racially identifiable gang, right? And so it's not permanent, but we got to observe him for a couple months. In our judgment, we are the wardens of the prison, right? In our judgment, this is the minimal way to do it. It's narrowly tailored. It's an important governmental interest, and this is a narrow way to do it. Other thoughts on the prison? Yeah, Quentin?
I feel this law relies on more like environmental conditions, meaning that if at this point in the history in this society it was more toward violence, racial violence.
Mm-hmm.
So
sure.
I guess today it's legitimized by the state of for example.
Right. So one of the sets of social facts that might be relevant is is it actually true that there's racially motivated violence in Virginia's prison population in 1965 or in New York's prison population in 2018, right? And if the answers are different, then maybe the constitutional balance would come out differently.
In 1965, it's probably constitutional, but it probably shouldn't be because if you isolate before prisoners reach general population, they're more likely to incite that kind of violence. So if you initially put them together and there's a problem, you might be able to fix it on a smaller scale. But once you go to the general population, you've got masses of people that have been segregated right from the start, probably going to create more of a violent environment.
So that does not sound unreasonable to me. I don't know if it's true or not, because I'm not a prison warden, right? But I guess my question is, how do considerations like that, which sound like they might make sense, how do considerations like that relate to the constitutional question?
I mean, you have to have a team of experts or people that would have statistical evidence to back that up, but unfortunately you have to beat the Constitution because the Constitution says at the time that it's legal to do so.
Yeah. What do you mean by that part?
I mean that it's legal for Virginia to continue these practices because there's nothing in the Constitution that denies them the absolute right to do so.
Okay. So what is for all of these questions, what is the relevant provision of the Constitution that we're talking about here? What's the most relevant?
The states' rights.
So that might come up, but I don't think that's the most relevant.
14th, equal protection.
Yeah, which says what exactly?
All citizens should be equally protected under the law.
That's close. What's the next?
Cannot mean one thing when applied to one individual as opposed to another.
Well, it doesn't say that. We're going to figure out what it means, but what does it actually say? Yeah. Yeah, no state shall deprive any person, not citizen, by the way, which was intentional. No state shall deprive any person of the equal protection of the laws. Does this prison policy deprive any person of the equal protection of the laws? Brian?
You say no because if they're going to be segregated to identical cells, it just happens to be temporarily racially based. I mean, probably you'd have to have an expert justify the 2-month part.
Yeah.
But if they were able to reasonably justify it, would that not be equal? It's in the same prison.
On its face, it does not seem to treat anyone unequally.
But isn't this the argument in Plessy? That it's the same railway cars, the same prison, you're just housing them in different parts?
It is indeed. It's an argument in Brown, too. Most of the time they were lying when they said the railroad cars or the schools were the same, right? Most of the time they were not the same. But in this prison, hypothetically, they're actually the same. It is the same prison. It's the same wing of the prison. Here's some cells for 2 African-American prisoners. Here's some cells for 2 white prisoners. At least for purposes of our discussion, the cells are identical. So it does not treat anyone unequally in one way, but that is an argument that was sometimes used to justify other forms of segregation.
And the difference between Brown and Plessy in this scenario would be that the other two don't have any real safety concern, and this is gone because the state has an obligation to protect the workers and the prisoners.
So prisons and schools are 2 different contexts, for sure, right? And schools, there's safety issues in schools, obviously. But obviously it's 2 different policy contexts, right? And so the government, in each of these cases, the government is going to try to come up with some kind of justification, right? If the government wants to have some kind of racially discriminatory policy, and if somebody challenges it in court, the government's trying to come up with some kind of justification. So in the prisons, the justification is going to be something about safety of the inmates and of the guards, right? And so that sounds important. In schools, the justification is not going to be the same, but they did still say that they had really good justifications, right? They said that it was going to be, they did raise safety concerns, right? They were scared of black kids being near their white kids, right? They also said that education, everybody was just going to, because folks were separated in every aspect of public life, right? This should continue in the schools, and it's going to help everyone concentrate on their schooling more. It's going to, I'm trying my best to make it sound plausible in some way, right? It's schooling for both white, they definitely said this, schooling for both white kids and black kids is going to be better. We are going to provide better education if the races are kept separate as they have always been kept separate. So it's not quite the same safety, but they do have a reason in the schools. Like, why would that reason be okay but not this one?
Because that one was this is 2 different cells in the same building or institution. Those are 2 completely separate entities.
That's true. That's true. That's true. Although remember, all right, I'll leave it at that. That's true. Quentin?
I will bring back again the argument of personal development. That in a cell, it's again temporary, and a person will end up in prison. But in school, it's cheaper, right? So it's different type of. You're basically segregating at a different point in life that make big shifts in the mindset of the individuals and shape the way they socialize.
Yeah. That seems like another relevant difference to me, right? Temporary segregation of inmates. I mean, Colin raised some concerns for us about what if we found that temporary segregation had the effect of exacerbating racial problems, because the first friend you make in prison is going to be your same race every single time, right? That might be bad. But still, temporary segregation of inmates for 2 months is probably of adult inmates, is probably having less of a harmful effect on those inmates than permanent segregation of children, in schools on the basis of race, where one of the things the Supreme Court emphasized in Brown, if you go back and read that opinion, is that this is really going to harm these African American kids for their lifetimes, right? It's going to affect their hearts and minds in ways unlikely to ever to be undone. That's the way Chief Justice Warren put it, right? That seems different, right? Let me put another example on the table for our conversation, the marriage question. Everybody said that one's unconstitutional. How does that violate the equal protection of the laws? The law says white people are not allowed to marry black people, and vice versa. Treats everybody equally.
In the case of Loving versus Virginia was the one where it said that it had nothing to do with like individual liberty. So saying that it kind of curtailed the individual liberty of both races in that way.
So one of the things they say in Loving versus Virginia is that there's a fundamental right to marry, which is not in the constitutional text, but they say there is one, right? And that this seems to violate the fundamental right to marry. But they also say, in that case, that it violates the Equal Protection Clause. So focus on that for a second. State of Virginia's ban on interracial marriage. Why does that violate the Equal Protection Clause? Marcus?
Isn't it a deprivation of life and liberty to not be able to marry who you want to marry?
No, so that's the due process clause, right? So yes, the argument, one of the arguments is that the right to marry is part of the word liberty. I don't know about life, but it's part of the word liberty, right, in the 14th Amendment due process clause. And so if you say you can't marry the person of your choice, that violates your liberty. But they also say it violates your equal protection.
So would it be that an interracial couple is deprived of certain rights that married couples would be given by the state, and that they deserve an equal protection as, an entity together, which would justify their marriage?
Okay, I think I see that. So like an interracial couple is being treated differently from a single racial couple,
right,
partly on the basis of race, on the grounds that one of them is African American, right? So I'm going to push back a little bit on that. The 14th Amendment says no state shall deny to any person the equal protection of the laws. So the lawyers might say, yeah, all right, which person is being treated unequally, right? So it doesn't apply to a couple. That's got to apply to a person. And if white people are prohibited from marrying black people, and black people are prohibited from marrying white people, and the state's lawyers are saying we don't treat anyone unequally, we have just always tried to keep this stuff separate, why does that violate it? The court still says it violates the 14th Amendment in 1967, is when it finally gets to that point, but why? Nachman?
Because it abridges the privileges of the citizens.
So that's another provision in the 14th Amendment that we could turn to. No state shall abridge the privileges or immunities of citizenship. Is the right to marry a privilege or immunity of citizenship? Maybe it is, right? That is a plausible legal argument that they do not rely on in Loving versus Virginia. And the way I think of it conceptually is the Privileges and Immunities Clause potential arguments and the due process liberty potential arguments are kind of one category, where the focus would be on what is the liberty that's being invaded. And in this case, it's the right to marry. Do we think that's important? Yes. Okay, so the state has to have a really good reason for infringing it, and we don't see that here. But I'm focused on the equality argument for the moment.
I mean, I guess it could maybe have to do with the fact that there's no restrictions being placed on marriages between people of the same race. So, like, if they're saying that whites and blacks can't marry, well then, who's to say that whites and whites can marry? Like, you're sort of bringing up this hole in the argument there.
I'm not sure I totally follow that. I mean, the state, yeah, white people can marry whoever they want, as long as they're white. And black people can marry whoever they want as long as they're black, right? I mean,
So I guess if the law is saying that white people can't marry black people and vice versa.
Yeah.
that is depriving of equal protection, because there's no restriction, for like the white people, like if the two people of the same race want to get married, that's fine. So like why is that not being extended to anyone, to everyone?
We're getting there.
I think allowing laws to make distinctions based on race perpetuates a racial hierarchy and racial classification that's unequal. So, a kind of a way to think about this, I think, is that like the Warren Court and courts that would decide this see only on a level playing field would complete equal protection of the laws be fair and just, but because society is already unequal, sometimes acknowledging that inequality requires a positive interpretation of the equal protection of the laws. I guess a positive, right? That requires government action.
Yeah, and tell me again how exactly that applies to the marriage case.
So in the marriage case, basically, because blacks and whites were treated so differently and that there was a racial hierarchy, continuing that racial hierarchy by claiming the distinction that essentially you shouldn't mix races allows the state and society to, perpetuate systemic racism.
Yeah, that's good. I'm going to say more about that in a second.
So I'll try to come a different direction. You could say that there's no issue with not allowing either race to marry interracially. However, the effect of that ban is not fair between the two races. So the effect of not allowing white people to interracially marry is not equal to the effect on not allowing black people to interracially marry.
Mm-hmm. I think that you can tie some connections between this and the women's rights movement, how they were against arbitrary distinctions between males and females, and even if the treatment under the law didn't necessarily make them unequal in society, the outcome of the law, if the intention of the law was to create some sort of hierarchy between men and women, like a hierarchy between the races, then they thought that should be stripped down.
Yeah, so these are all good comments. I'm going to try to sort of tie them together. I'm going to give you 3 different reasons why the interracial marriage law might be unconstitutional. And again, the starting point is that from at least one perspective, like this is not wrong in a way, from at least one angle, the law does not treat the races unequally, right? From one angle, this is what the state of Virginia's lawyers said for years. We are not treating any race unequally, right? They said the same thing about schools and train cars too, right? We're not treating any race unequally. We're just saying they got to be separate. There are, I think, still at least 3 potentially really good arguments for why the ban on interracial marriage is unconstitutional. And I'll give you all 3 of them. Three different versions of an argument for why Virginia's ban on interracial marriage is unconstitutional. One is it has discriminatory effects, right? The law is part of a whole system of legally enforced segregation in the state of Virginia, whose whole purpose is to keep African Americans subjugated, right? And one of the things we got to do to keep African Americans subjugated in an inferior position in our society in Virginia is to maintain white racial purity, right? If we got people mixing, right, we're not going to have clear lines between the races after a couple of generations. And it's going to be harder to keep African Americans down, right? So this law, together with all the other laws that it is associated with, has the effect of fostering a racially unequal society in Virginia. Here's a different argument for why it's unconstitutional. The ban on interracial marriages has a racially discriminatory purpose. The reason that they enacted it, and the reason they continue to enforce it, is to maintain and defend white racial purity. That is discriminatory, right? That's the whole purpose of the law, right? It is a racist purpose. the law is motivated by a desire to maintain racial inequality. And here is a third, slightly different argument why the law is unconstitutional. The state has no business classifying persons on the basis of race for any reason. Whether it's treating them equally or unequally, why is the state dividing people up by racial categories? Right? If the law classifies Virginians on the basis of race, right, that in the text of the law, if it says white people do this and black people do this, that's unconstitutional. Even if it's giving nice things to everybody. Right? You got lots of people to marry, you got lots of people to marry. Everybody's fine. Right? But why are we dividing the citizens of Virginia up into different racial groups? That by itself is unconstitutional. All three of those arguments work, potentially, for Virginia's ban on interracial marriage. All three of them also work in Brown versus Board of Education. Right? Does the school segregation policy in Topeka, Kansas have racially discriminatory effects? Yes. Was it created for a racially discriminatory purpose? Yes. Does it, in the text of the law itself, divide people in Kansas into two different racial groups? Yes. All three of those arguments work in Brown versus Board of Education. And all three of them work in Loving versus Virginia. But there are some cases that emerge, starting during the Warren Court era, but even more so in subsequent periods, where it matters which one of these interpretations you adopt. Right? Does the Equal Protection Clause ban all three of these things, or only one of them, or only two of them? Right? It does not really matter in Brown versus Board of Education. If the Equal Protection Clause bans any of those things, then Topeka's school segregation law is unconstitutional. But in subsequent cases that come up, including the prison policy, including the civil service test for state police officers, including affirmative action in university admissions, for all of those legal questions, it matters which one of these we think is the right one, right? Or it could be two of them, or it could be all three of them, right? Which ones of these do we think are included in the Equal Protection Clause that the 14th Amendment imposes on the states? Right? So let me say just a little bit more about what the Warren Court said about this, and then we'll look at some of the more recent disputes, and then we'll continue that conversation on Thursday too. So in Brown itself, it's hard to tell which one of these the court was thought most important. If you had to pick from Warren's actual opinion, you would say the first one. Right? Warren's actual opinion emphasizes the impact of racial segregation on African American kids. Right? Going to harm their hearts and minds in ways unlikely ever to be undone. Right? That seems to be what he emphasizes. But if you look at some of the immediate, right, so Brown comes out in 1954, and then Brown 2 in 1955, they say all deliberate speed, and then all the school districts around the South are trying to figure out, are we going to comply or not, or what if we tweak our policies like this, or maybe we don't have to change everything, we can just ignore it. And so there's all these subsequent lawsuits filed, and so there's lower federal court judges all around the country trying to decide school segregation cases after Brown. And in the immediate wake of Brown, most of those lower court judges said, the real issue is this one. Does the state have a law that classifies people on the basis of race or not? Right? The actual text of the law. Is there a law that says African American kids are not allowed to go to this school? That's unconstitutional after Brown. But if they repeal that law, then they're fine. Right? If they repeal that law and says every kid goes to the high school that's closest to her house, right? And that's our city. There's train tracks down the middle. This is the white side. That's the black side. There's the two high schools. Everybody goes to the school that's closest to her house. No integration happens. But initially, lower court judges said that's fine. That's not unconstitutional. because they got rid of the discriminatory text. The government is not officially discriminating against everybody anymore. That's what the court judges said initially. But in the mid to late 60s, the Warren Court came back with several additional school segregation cases. We talked briefly about some of them, Griffin versus County School Board and Green versus County School Board and the like. And the Supreme Court said, no, that's not right. That's not what we meant in Brown. In Brown, we meant this, and maybe we also meant this a little bit. They start to emphasize this one too, purpose as well as effects. If you are maintaining a law, the principal purpose and or effect of which is to maintain racial inequality, that law violates the 14th Amendment, whether or not it says something explicitly about race. So if you drew these neighborhood school lines like this, you built those buildings on those two sides of town, you drew the school line like that, I mean, why don't we draw the attendance line like that? Right? Then the schools are both 60-40. Right? It's not like God gave us the school attendance line, right? You drew it, whether it says anything about race or not. If its principal purpose or effect is to maintain racial inequality, then it's unconstitutional. That's what the Supreme Court repeatedly says in the late 60s. In the early 1970s, the Supreme Court extends that still further, and they say that in fact, the government might sometimes be maybe even required, but certainly allowed to classify citizens on the basis of race in order to address these, right? If we have a decades-old, century-old discriminatory public school system and we are trying to fix it, we are certainly allowed, and in some circumstances might even be required, to adopt a policy that says, here's our city with our two high schools. We can't afford to build new high schools at the moment, right? We're stuck with these two schools, one of which happens to be on the white side of town and one of which happens to be on the black side of town. And so every kid's going to get to rank order their choices, and we'll send as many kids to their first choice as we can. But in order to undo the racist system of schools that we have had for decades, we are going to have to ask each kid on the application to check off what their race is. And we are going to have to choose some of the white kids and bus them across town, and choose some of the black kids and bus them across town, even though some kids are not going to be going to their first choice high school now, because that is the only way to integrate the schools. And the Supreme Court says, yes, you can do that. You can for sure do it voluntarily. Like if the school board adopts this policy, says this is the best way we can think of to integrate the schools, you are for sure allowed to do that. Even though you are now treating people differently, you're now classifying on the basis of race. This kid is getting bused across town because he's white or black, and vice versa. You can for sure do that voluntarily, the court says. And there might even be some circumstances in which courts order you to do it. Right? If nothing else was getting rid of the policy that had a discriminatory purpose and effects, we might have to order a race-conscious policy to get rid of it. The Supreme Court says in Swan versus Charlotte-Mecklenburg, which is a school desegregation case from 1971 from Charlotte, North Carolina. Questions about that so far? Okay, so that's basically the Warren Court. Swan is in 71, so that's a little bit after the Warren Court. But that's basically the 60s and early 70s. Let me see, how much time do I have? What do I want to do? The court decides a swimming pool case in 1971. It's called Palmer versus Thompson. a federal court had ordered Jackson, Mississippi, to desegregate the public swimming pools, and the city responded by closing the public swimming pools. And you may remember that there was a similar case about schools earlier, where Prince Edward County, Virginia, had closed down the public school district rather than integrate it. And the Supreme Court ruled against the schools in that case. Supreme Court rules in favor of the city of Jackson, Mississippi in the swimming pool case. It's 5-4, and the 4 justices in dissent are like, no way, just like the schools, right? If you are shutting down the schools, even though in a way that is not discriminatory, right? We're shutting down the schools for everybody. We're shutting down the swimming pool for everybody. That's, on its face, that doesn't violate the Equal Protection Clause, because it applies equally to everybody. But if there's clear evidence that that was done for a racially discriminatory purpose, we refuse to integrate this swimming pool, instead we're going to close it down. Right? That is a racially discriminatory purpose. Right? 4 justices said that's unconstitutional, just like we said with schools. But 5 justices go the other way, and they're like, nope, a discriminatory purpose by itself we don't think makes a law unconstitutional. Palmer versus Thompson probably would have come out the other way if it had come a couple years earlier. Right? It's pretty similar to the Prince Edward County school case, which did come out the other way. But Palmer versus Thompson's in 1971, and 2 of Nixon's appointees are on the court by this point, Berger and Blackmun, and they are both in the majority in that case. And the court seems to be saying, all right, maybe we're scaling this back a little bit. Right? So like in the Warren Court, they're saying, by the end of the Warren Court, they're saying, all of these things are relevant. All of them are part of the Equal Protection Clause. All of them are part of Brown versus Board of Education. We're going to look at all of them in different circumstances, all 3 of these aspects of racial equality. The one we're probably emphasizing the most is effects, where we also think purpose is important. And maybe the least important is just the actual text of the law, because that doesn't always tell us what's really going on. In the 70s, the court seems to start shifting and saying, well, maybe all of them are important in some way, but we think the most important one might be the actual text of the law. Like, does the law actually divide people up on the basis of race? That's the thing we're mostly focused on, regardless of the purpose or effects, right? And so in the swimming pool case, they back away from the purpose a little bit, and in an employment case called Washington versus Davis, which is about the police department in Washington, D.C., the Supreme Court backs away from the effects issue. Police department in Washington, D.C. required all applicants to take a civil service exam, which was one of the contributing factors to why you had a majority black city with a majority white police force. The police force had, according to some lawyers and judges, had no really good evidence that the civil service exam was well designed as an actual appropriate job qualification for being a successful police officer, right? But the court said it was okay, right? It's non-discriminatory, right? Everybody's taking the same test. Did they give some kind of plausible justification for why you need to be able to pass this test in order to be a police officer? Yes, they came up with something. That's okay. The law doesn't discriminate against anybody, right? The text of the law does not say black people have to take this test, right? Literacy tests for voting, right? One of the problems there was that the folks who administered the tests would always give black people harder questions or just interpret their answers differently, right? They were verbal tests often. But that's not what's going on here. It's a written test. Everybody's taking the same test. It's non-discriminatory on its face. Somebody has produced evidence that it has discriminatory effects, but that by itself doesn't make it unconstitutional. That case also might have come out differently if it had come a few years earlier. That one's in 1976. The court in the 70s seems to be shifting in the direction of emphasizing this discriminatory text as the central component of what the Equal Protection Clause prohibits. And this is the context in which affirmative action comes to the court. Right? So the court's first affirmative action case is in 1978. It's a university admissions case from California. The medical school at UC Davis adopted a policy reserving a certain number of incoming seats every year for members of underrepresented minority groups. Right? There are not enough Black and Latino doctors in the country. Right? There's obviously a long history of segregated and unequal schooling in our nation's public schools. Right? On average, African American and Latino applicants to our med school, on paper, their qualifications sometimes look a little bit lower. Right? And so in order to make sure that we are admitting a diverse student body and training a diverse set of doctors, we're going to reserve a certain number of seats each year for members of underrepresented minority groups. Alan Bakke, is a white guy, applies to med school at UC Davis and does not get in. And he challenges this policy as unconstitutional. And he goes to the Supreme Court, and he wins. Supreme Court's voting alignment in the case is a little bit confusing. The justices divide up into three groups. The lower court had said two things. The lower court had said, Alan Bakke wins. This particular policy is unconstitutional, and they're going to have to admit him or pay him some kind of damages or something. And in addition, the University of California at Davis Medical School is prohibited from considering the race of its applicants moving forward. Right? They shouldn't even be looking at what race anybody is. 4 justices said Alan Bakke wins to win the case. Right? This particular policy is unconstitutional, and we agree that the university should be prohibited from considering race moving forward. 4 justices said Alan Bakke should lose. This policy is well justified and perfectly constitutional, and there should be no prohibition on the university should not be able to reimpose segregation, but there should be no prohibition on the consideration of race in an effort to produce a more diverse student body. And 1 justice split the difference, and he said, this was Justice Powell, Alan Bakke wins. This particular policy is unconstitutional, but I do not agree with the lower court that the university should never be able to consider race. There are some circumstances in which universities should be able to consider race in an effort to promote a more diverse student body. And in fact, several universities, including Harvard, have filed a brief in the case in which they describe their admissions policies, which are very different from the ones at the University of California at Davis. They are more flexible. There is no set number of seats set aside for anybody. Right? There's no strict racial quota. But they do consider the applicant's race as one factor among many in an effort to promote a diverse student body. That's what Justice Powell said. And that's okay, he said. So the practical result, right, is that 5 justices are voting to strike down this policy, this strict racial quota, and a different 5 justices are voting that universities are still allowed to consider race in some ways. let me say a little bit more. Well, let me just put one other case on the table. So university admissions is probably the one you guys know the most about for sure. Affirmative action comes up in other governmental contexts too, and the court sometimes gets cases from these other areas too. Another really common context is in government contracting, right? So we're going to build a highway, right? Long history of racial discrimination in the construction industry. So if the government just does like a normal bidding process to like which contractors give us the lowest bid, and that's who's going to build the highway for us, then the government is funneling millions of dollars almost entirely to white-owned businesses, right? And so the government, state and federal, start adopting policies that say anytime we got a big public works project, X percentage of those government dollars have to go to minority-owned firms, or sometimes they say women or minority-owned firms, right? So whatever they decide, 10%, $100 million project, $10 million at least of it has to go to firms that are owned by women and or minorities. And white contracting firms have challenged those policies too. And in a case in 1989 from Richmond, City of Richmond City Council had adopted one of those policies. White-owned contractor challenged it. He made his way to the Supreme Court, and he won. The Supreme Court struck that policy down. That one was 5-4, right? In both of these cases, Thurgood Marshall dissented. Right? 4 justices dissented in both of them, but Thurgood Marshall was one of them. So let me say, I want to say a quick word about the majority in the case, a quick word about Thurgood Marshall's dissenting opinions in these cases, and a quick word about Justice Powell's effort to kind of figure out some spot in the middle, which is still important to this day. So the majority in Richmond versus Croson, who's striking down the policy, and this is complicated in Bakke, but the majority that's ruling against Alan Bakke in University of California versus Bakke, so that conservative side of that case. The majority says a couple things in these cases. They say the Equal Protection Clause applies to all persons, right? It doesn't apply to racial groups. It applies to individual persons, right? That's what its text says. No state shall deny to any person equal protection of the laws. And they say that the central meaning of that provision of the Constitution is that the government should, I want to say never, but they almost never, basically never, with very rare exceptions, the government should not classify persons on the basis of race for any reason. Right? Justice Scalia writes a concurring opinion in the contracting case in which he says, the only exception I can think of is where it's an immediate matter of life or limb. For example, prison authorities temporarily segregating inmates to prevent a race riot. Right? That would allow the government to classify people on the basis of race when there's an immediate threat to life or limb like that. But otherwise, our Constitution should be colorblind. And the government should not pay any attention whatsoever to persons' races. Justice Marshall, right, Thurgood Marshall, civil rights lawyer, who won all those cases for the NAACP, appointed to the court by LBJ, first and for many years only African-American justice on the court. He thinks this is crazy, right? In both Bakke and in Croson, he says that for most of our history, most of our Constitution's history, we, this very Supreme Court, we held that the Constitution did not prohibit the most ingenious and pervasive forms of discrimination against African Americans that people could come up with. Now, when a state is acting to remedy the effects of that legacy of discrimination, now is when the Constitution is prohibiting stuff, right? For 150 years, like blatantly racist stuff was not prohibited, even for almost 100 years after the 14th Amendment. Blatantly racist stuff is not prohibited by the 14th Amendment, but now anti-racist stuff, policies that are designed not to subjugate members of a particular racial group to an inferior status in society, policies that are enacted not with the purpose of keeping one racial group down, policies that consider people's race in an effort to ameliorate racial discrimination. Now we are saying these ones are unconstitutional. Richmond, Virginia, from the contracting case. Richmond was the capital of the Confederate States of America. A long and rich and well-documented history of racist actions taken by the government of Richmond, Virginia. A long and well-documented history of racism in the construction industry in Richmond, Virginia. And now, in the 1980s, when the Richmond City Council, of its own accord, voluntarily, right, the elected leaders of the city, voluntarily, of its own accord, adopts a policy saying, okay, 10% of city contracting dollars have to go to minority-owned firms. Now we say that's unconstitutional? Are you kidding me? Marshall says. That is the opposite of what the 14th Amendment was enacted to accomplish. Right? And in fact, the men who wrote the 14th Amendment in the 1860s, they themselves enacted the law creating the Freedmen's Bureau, which was an effort to provide race-conscious governmental assistance to the recently emancipated slaves. It never carried these plans out very successfully for very long, but the plan initially was recently emancipated slaves, each family should get 40 acres and a mule, right, given to them by the government, seized during war, right, land that was seized mostly by Sherman's army, march from Atlanta to the sea. We're going to divide it up into 40-acre plots and give it to the former slaves. Explicitly race-conscious government efforts. Those are the guys who wrote the 14th Amendment. They were trying to figure out ways for the government to help address racism, including race-conscious ways. 100 years later, Richmond City Council is trying to make some modest effort to do something similar, and we're striking it down. That's Thurgood Marshall's argument. Justice Powell in Bakke, and then Justice O'Connor in Richmond versus Croson are trying hard to come up with some kind of middle ground here. Right? Justice Powell says in Bakke, Equal Protection Clause applies to all persons. It applies to white people as well as black people. Right? If the government is discriminating against a white person on the basis of race, that potentially violates the Equal Protection Clause. It applies to all persons. However, there are sometimes some very good reasons for which the government should sometimes classify citizens on the basis of race. And I think educational diversity is one of them, Powell said. We have these briefs from Harvard and a bunch of other universities that their fancy lawyers filed. They make a good case, right? We don't got enough black doctors. We don't got enough black lawyers in the country. We don't have enough black college graduates in general. We are trying to diversify the leadership ranks of this country. We need to diversify our universities. The universities are also telling us that the educational environment is improved, even for white students. If there is a racially diverse campus, students are going to graduate and go off to work in a racially diverse world. They need to learn in a racially diverse environment. That's what the universities are telling us. I think that's a compelling governmental interest, Powell says. Contracting cases are a little different. There's no exact direct parallel to educational diversity. But O'Connor has some language in the Croson decision that sounds somewhat similar. And so as of 1989, the court has been saying We are somewhat dubious of race-conscious affirmative action, but we can think of some circumstances in which it is justified if the policy is narrowly tailored, crafted carefully enough. For example, in pursuit of educational diversity, we think that's a compelling reason. That is the existing legal context for a new wave of challenges to affirmative action, especially focused on affirmative action at the University of Michigan, that comes to the court about 15 years ago. And those are the main cases that we're going to look at next time. So we're going to continue this same conversation. So make sure you take a good look at those Michigan cases.